I think one of the key takeaways is honest and genuine compliance with your own internal processes, setting aside that it might not always be good for the psychosocial health and well-being of your people, which is disappointing, will often be your best evidence of whether you're taking reasonable management action. So I think that is something that organisations need to grapple with.
The concept of psychosocial risk is far from new, but the dialogue and industry discussion about the topic has elevated since regulatory changes were announced in 2023 and 2024. Psychosocial risk is now the focus of many conversations in the corporate world, from boardrooms to executive teams, and of course through to the practitioners on the ground, trying to join the dots to have meaningful impact. I'm Kate Connors. I'm a master's qualified psychologist, and my professional purpose is to help people and workplaces be at their best.
And I'm Greg Smith. I'm a lawyer who's spent more than 30 years practicing in the areas of employment law and workplace health and safety. I'm also the author of several books, including Paper Safe and the recently published Proving Safety.
And you are listening to Judgemental, when a psychologist and a lawyer walk into a barside chat about psychosocial risk. A big thanks to our sponsor, EML. EML are Australia's largest personal injury claims provider, providing claims management services to workers' compensation, life insurance and CTP markets with the purpose of helping people get their lives back. We have another jam-packed episode today, so grab a drink and sit back for another discussion at the bar. Hello listeners, welcome again to another episode of Judgemental. My name, as you probably are aware, is Kate Connors, and it's wonderful to have you with us today. Before I introduce my partner in crime here, I'd like to make sure I recognise and pay my respect to the elders past, present and emerging on the lands that I'm recording on today and having this conversation, which are the Wiradjuri lands of the Kulin Nation. And over to you, Greg. Good morning. Well, it's morning for me. Oh, no, it's morning for you
Kate,
too.
Yeah, morning over here. I'm on the lands of the Whadjuk people of the Noongar Nation today, and I would like to acknowledge their elders past, present and emerging also. And how are you today? How are you? You well?
I'm good. I spent the week in Sydney this week. So I got back last night, caught up with some lovely people up in Sydney, like to keep the relationships, IRL. It's all about IRL, Greg.
What's IRL?
In real life.
Oh, okay.
That's me. I like in real life rather than just virtual conversations and things. So that's what I did this week. What about you?
I'm in the middle of a ton of stuff at the moment, and I've got some travel coming up, so I'm just trying to stay on top of everything.
Workload demands, Greg. Workload demands.
That's what it is.
They're everywhere. So here we are in our second episode of our deep dive into reasonable management action, which obviously is much more in your wheelhouse than mine when we think about the structure of how we've set up this podcast for the legal view and the human psychologist view. So, and reminding everyone that this was the top of the list of the votes in terms of topics that people were interested for us to have conversations about. So you found a case for us to discuss today. Oh, hang on, drink. What are we having to drink? I always forget. We're in a virtual bar. Bar. What are we drinking?
Oh, it's only 10 o'clock over here, but let's pretend it's not 5 p.m. somewhere. I'll just have a white wine this morning. Just a Semsav, nice Margaret River Semsav.
Okay, nice. I actually feel fresh and awake. So I'm going to have a sparkling water with lime. Today is my drink of choice, just to keep it fresh.
Lovely.
Yes. So, but I interrupted to make sure we got our drink orders done. So over to you. We've got a case to discuss.
Yes, and again, I think we need to point out this is kind of one of those classic overlaps between our two areas. So you've got psychology on the one hand, law on the other. what the idea of reasonable management action doesn't do is say that harm did not occur. So there's ongoing issue that we have in that
yes.
a person.
So it took my brain a little while to catch up to what you just said there. Did you see that in my face? I was kind of like, hang on, what's he saying? Now I'm with you.
You know what I mean?
Yes, it doesn't. Yes.
So I do. I can take perfectly lawful conduct against an employee and they can still suffer severe psychosocial harm. So the law is a very imperfect instrument for managing the risk we're talking about. And we'll talk about this more next week because we go
with the workers' comp overlay. Yeah.
So, and what we see happening just this week, I think, might have ended last week in New South Wales with the proposed changes to legislation, which is really saying we are restricting significantly, by the looks of it, restricting people's abilities. And I think Victoria's proposing something similar.
Yes, they are.
Restricting people's abilities to bring psychosocial claims. And so what we are talking about here, importantly, is a very, very real distinction between the management of psychosocial risk and the management of legal risk.
But we're also, if I just follow that thought bubble, we're also talking about that considering the legal frameworks, whether it's in a workplace health and safety context or in a workers' compensation context, there is...
Or in an anti-context.
Or in a reasonable management action anti-bullying, there is something can be deemed to have been managed in a reasonable way, but that's a totally separate path or journey to someone has been harmed.
Yes.
Yeah.
Yes.
And I think at a psychological level, that is exceptionally difficult for a human being to get their head around.
Yes. And I think what makes it a little bit more conceptually difficult is that the gulf between psychological risk management and legal risk management is far wider than it is between physical harm and legal risk management, because you don't get that same distance between the two things.
Negligence, kind of, the clarity of negligence almost,
They tend to be much closer. So if somebody is physically injured at work, the likelihood that I've failed to manage the physical risk and the legal risk is much higher, whereas somebody is psychologically harmed at work, the gap between the management of the psychological risk and the legal risk can be much wider. Yeah.
And you know what?
So it's an interesting dilemma.
And I think where my brain goes as well on thinking about that almost humanly, psychologically incongruent coexistence is that at a really high level, at a societal level, that is almost, or well, it kind of is saying, at a values perspective, we just can't afford to have the same care provisions in place. That's essentially why the schemes are bringing in, or the legislation is coming through in New South Wales and likely in Vic, because we can't afford to care through the workers' compensation schemes for the psychological harm because it's just happening too much. Would that be fair?
Probably. I mean, let's digress one little bit here.
Yeah.
I think the real concern is it is hard enough at the moment for people to raise mental health and wellbeing in the workplace. And I think now the potential risk we're seeing is what we're going to do is we're going to create a legal framework that a lot of people are going to come out the backside of it and other people saying, see, it wasn't true. We don't believe you. You're just making this up.
But that's not actually what the legal position is. It's just that.
But I think that's what it's going to end up looking like. So if I've got to go to court to prove that I've got a certain type of claim before I can then get into the compensation system, which it looks like the New South Wales model, then all of a sudden we're going to have this whole, because if I lose my arm at work, I don't have to go and say, so it's this whole thing, we can't see it, therefore we don't believe you.
Which in and of itself is more harmful.
Oh, I would have thought so.
Yeah, no, it is.
Again, without being a psychologist, I would have thought so.
Well, being a psychologist, I can tell you it is. Yeah. So,
which is why we're here, Kate. Which is why we're here.
Okay, let's get on. Tell us about this case that you've discovered. But I'm really keen for you to also share, because this case is an anonymised case. So can you tell us a bit about I didn't even know that that was possible, that people could take things through to a commission and it end up being an anonymous decision in the public domain. So tell us a bit about that as well as the case itself.
All right. So the decision is just called Ms. SB. So as you say, it's very anonymised. It doesn't say who the parties are. It doesn't say who the employer is. It doesn't provide any of those details. It is not, and this is an anti-bullying case. So it's an anti-bullying case in the FairWork Commission. Anti-bullying provisions have, within the legislation setting up the anti-bullying jurisdiction of the FairWork Commission, there are specific exemptions around reasonable management action, which is why it's one of the areas that it gets looked at a lot. Reasonable management action comes up the most in workers' comp and anti-bullying. So we're looking at anti-bullying today, and I'm going to get a workers' comp expert next week to have that discussion. It's anonymised, and it often happens. So this is a non-dismissal bullying application. So all of the parties involved are still working for the employer. And so in part, these things get anonymised to try and help salvage the situation. So if we don't put out a public document so everybody knows who's involved and everybody knows who the employer is, it might give the parties a better opportunity to come back together. I think that's probably the main rationale behind it. The Commission has always had jurisdiction to anonymise its proceedings because, particularly if there's circumstances of serious misconduct that could be very damaging to the people still involved and those sorts of things, but they will often do that as a protective measure.
Can the applicant seek that? Does the applicant have to say, I want this heard in an anonymised way? Or how does that work?
The Commission can do it off its own initiative, but the parties can apply, but the Commission can do it on its own initiative.
Okay. Right. The case itself then. Tell us.
All right. So the Miss SB, and you've read the case, I know that, and there are so many initials and acronyms in this case. It can sometimes be hard to follow who's who, but so we'll call Miss SB was the applicant. So it's even not particularly clear about the business because it's not named, but you read the judgment. She was what's called a delivery support team leader, and she had a manager of a team of what were called delivery support officers, and they were in 2 operational locations. Miss SB, the applicant, she brought a claim, a bullying claim in the FairWork Commission seeking various orders to stop bullying and other things. Interestingly, there had been an earlier bullying complaint against the applicant that had been investigated by the company and dismissed, and then the person who brought that complaint eventually left the company. So that's sort of a bit historical.
Aside.
But then you get this kind of tit for tat issue where one employee brings a bullying claim against her and she responds by bringing another bullying claim back against this person, and she takes it to the Commission. And it's interesting. So some of the things, and sorry, I'll go back a step. One of the things, and it's not uncommon in the anti-bullying jurisdiction, is the applicants are often self-represented. And when you have a self-represented applicant, it can often muddy the waters quite a bit and can make the application a little bit untidy from a legal perspective. There's nothing wrong with it, but it's just you're often dealing with issues that have nothing to do with the legal position you need to argue about. Because it's not a general, you come in, tell all your stories, and I'll work out what the best outcome is. It's no, there's criteria you have to meet to either get within the jurisdiction or then to be successful. And so you can get a sense reading this judgment, Commissioners filtering a bit, trying to work out what's relevant. But when you look at the claims, well, the things that the applicant says makes up the bullying, a couple of them are quite interesting. The first one is that people made a complaint of bullying against her. So she says, well, that's bullying. Then she says the fact that the employer accepted and investigated those complaints was bullying. Now, spoiler alert, the case says, no, it's not. And I think if any lawyer would have told her that, so that wouldn't have gotten into the mix. This was an interesting one. She says that, so I mentioned there was an earlier bullying complaint by someone referred to as NP. So NP makes this complaint, the employer investigates it, and they says, no, that's not bullying, and the complaint's dismissed. But she says that the employer took no adequate action to prevent similar conduct, i.e. to prevent further complaints being made, which is interesting. So I don't think any of those ones fit the bill. She goes on to say she was the target of ongoing malicious rumours without receiving support. That clearly could constitute bullying. She was being harassed and badgered on a daily basis by somebody called CC, who's one of the complainants as well. She said CC was documenting all of her conduct, and I can see how that could constitute bullying. And she was being humiliated as a consequence of rumours and gossip because the employer didn't notify employees about the outcome of the complaints. So that's broadly it. She says, people made complaints about me. One of them was dismissed. You didn't do anything about it. And I was subject to this ongoing bullying and harassment and rumours, and you didn't do anything about it. So that's kind of, that's the environment. That's what the bullying claim looked like.
And I also think, just to add to that, what I thought was interesting on reading this decision is typically within workplaces, the idea of the power differential is a key component that's considered in terms of bullying. And in this particular application, it is the person who was the manager who is alleging that they were bullied by people within their team. So that is also, I think, for people listening, in terms of just getting their heads around some of the workplace dynamics as we talk this through. It is, I think, really important to note that they were the manager, and that it's the manager that is submitting the application around the bullying.
Yep.
From someone who reported to them. Yeah.
And it's an interesting one. I don't have any research or numbers or anything like that, but my sense is that that is less common, that a manager would bring a complaint of bullying. And I think that's got to do a concern about how they would be seen to be operating in their job.
Exactly.
That if they have to bring up applications of bullying against their staff, then clearly you can't manage your people or something like that, which, and I know we've moved on from the whole leadership wellbeing issue, but I think that's got to be.
Look at you go. That's exactly where I was going to say. Listen to you, Mr. Smith. No, exactly right. It's such a critical factor for leaders, is that they feel that they are subject to scrutiny at levels that they don't have agency, or the same levels of agency that employees do, or even though they might be their employees often themselves, because of that organisational undercurrent. There is a stigma for leaders to claim protections in regards to the way that their staff are towards them. So, I think that I just thought that was an interesting one to make sure we kind of called out. Yep. Okay, so where to?
Nice to see that I'm learning. I just want to, before we start to talk about sort of how this thing played out, there is one point, and for those following along at home, it's paragraphs 32 and 33 of the decision. And you will know, because this is one of my bugbears, you still have to run your case properly. So you get to 32 and 33, and you see there's a witness statement for the applicant that was unwilling to provide details of incidents summarised in her statement, which said, "Can't give any weight to the evidence on critical issues. If you're not going to give the details of what you say, if it's just bland, I can't give weight to that." And then 33, both parties sought to rely on statements that were apparently made by persons who were either unwilling or unable to attend to give evidence, and have given basically no weight to the evidence because it couldn't be tested.
Yeah.
And this has come up in these psychosocial risk claims.
Yeah.
That issue of people not giving evidence seems to come up far more often than in other types of claims.
Which is the fundamental kind of question in regards to broader psychological, and this is again, making sure that we're clarifying terminology, but to me that speaks to the psychological safety, not psychological health and safety, but that sense of being able to say what you need to say without fear of retribution and retaliation. Within like that, I think is really relevant. Yeah. Like if people aren't feeling comfortable to provide witness statements or to say what they think, or just to say what they observed, ultimately is what happens in these kinds of situations, isn't it? It's not necessarily what they think, it's what they observed or what they experienced. Then that in and of itself, it is a data point, in my view. Yeah.
Yep. I think that's right. So the case then goes on to describe, what is bullying, and they talk about it being repeated unreasonable behaviour by the individuals towards the applicant. So again, there's a problem here that objectively, so as a psychologist or just as a person, you can look at behaviour by a person. You think, oh, that's not right. You shouldn't behave like that, whatever it is. But that's not the same thing as saying that it jumps through all of the hoops it has to jump through to fall into the definition of bullying.
Yeah.
Yeah. And the reasonable, and this comes to your point about people's perception, and this I think is part of the problem. I can perceive behaviour in a particular way and I can internalise that and it can cause me harm, but the test of the unreasonable behaviour is an objective test. So how would a reasonable person perceive what had happened, having regard to the circumstances, and it has to create a risk to health and safety. That's also within the definition. So, and I think for lots of people, and I think we're seeing this happen a lot at the moment, people have latched on to psychosocial risk, and I think they're particularly latched on to this notion of bullying. And I think a lot of people carry into the workplace a very juvenile schoolyard perception of what constitutes bullying, and they don't realise that is a different issue from whether or not it fits within the relevant legal definition. So, and then we go on, the court talks about, again, if you're playing at home, it's paragraph 47, talks about the exclusion. So the behaviour, it has to be management action. So that's so at what point is it management action compared to the action of somebody who's either not management or not acting on behalf of management? It has to be reasonable and it has to be carried out in a reasonable manner. And there's a few parts of the test.
Which is the what and the how that we talked about last time. The what and the how. Both need to,
Yeah, the what and the how. But there's a couple of really interesting things that I think you would find, or maybe you have and you'll come to them, but I'll point them out first. The test of whether action is reasonable is not the same as saying what you could have done something more reasonable or more acceptable.
Yeah.
So it doesn't have, it's not best practice.
Yeah.
Okay, so that's important. It doesn't have to be perfect or ideal. So again, not best practice. And this is one that I think most people wouldn't probably pay much attention to, but I think it's important. So a course of action can still be reasonable action, even if a particular step is not. So within a framework of dealing with an issue, you could take some unreasonable steps, but overall the action might be reasonable, which again, putting my pseudo-psychologist hat on and waiting to be corrected, it could be the single unreasonable step that causes the harm, yet the overall action is still found to be reasonable. And again, where we get this other disconnect with harm, and I thought I've touched on it, but the court goes on here to say unreasonableness must rely from actual management action in question rather than the applicant's perception of it.
Yeah.
I think this is the balance we're trying to find in legislation or in public policy, maybe even more broadly, is that legitimate harm can be caused by an individual's perception of conduct or behaviour or action.
Yeah.
Legitimate harm. There's nothing.
Actual harm.
The fact.
Real harm.
Yeah, it's
no one's doubting that there's harm.
They're hurt, they're damaged.
Yeah.
But was that a reasonable reaction?
And I think that psychologically, why this is so complex to systematise and regulate and have judgment over is because considering an individual's background, personality, life experience, family experience, it can make absolute sense from a meaning-making perspective and a conceptualization psychologically as to why someone is harmed, why that particular person is harmed and hurt and hurting. But in a legal context, that's not what's actually being ruled on. And I think that this is where this stuff has such complex intersection, is that psychologically, and I've seen this happen time and time again with clients that I've worked with over my career, there is this blurring of the use of a legal process to try to bring a sense of justice or a sense of meaning, or to feel that their level of hurt or harm has been acknowledged. And that is actually really important for their psychological well-being and their psychological recovery and journey. But what's just so difficult is that you just don't get that from institutions such or legal remedies because of all of the things that you're talking about. The legal structures just aren't established to do that. And that, I think, takes us back to our conversation. As we're talking, Greg, I'm really thinking a lot about that conversation that we had last series about, the level of comfort around conflict in a culture, how cultural design needs to lean into as a genuine mechanism of control around bullying, to use your phrase before, educating and creating that cultural design that we don't do juvenile, to use your word, that sense of juvenile response to conflict around here. This is an adult environment. We support people with all of their differences, but we also tell the truth about how we navigate times when we disagree and there is discomfort. And I just don't, I think that's such a complex thing to create systemically. And that's why we're not seeing organisations kind of go down that kind of path maybe. And because it feels easier just to kind of latch on to, someone's hurt me and I'm going to pursue bullying. I don't know.
But isn't that where organisations fall into the procedural fairness trap? And we mistake procedural fairness. So what you talked about is this sort of process to acknowledge.
Yeah.
Here's procedural fairness. You get to have your say. We will listen to you, what you have to say. We follow that process. But people can often come out the other side of that not feeling heard at all.
Exactly.
Everything has been done is perfectly appropriate, perfectly legal, perfectly in accordance with the procedures. It's interesting because when you look at, I've just lost the paragraph, but you go back to that paragraph I was talking to a moment ago. Bear with me for 1 second.
47, I think it was. Yeah.
Yeah, 50 down to 51, and the last bullet point there where it says consideration may be given to whether the management action involved a significant departure from established policies and procedures, and if so, whether the departure was reasonable in the circumstances. So there's almost this default position that if you assiduously and mechanistically follow your processes, grievance procedures, for example, then almost, I'm not saying this is 100% true, but almost by implication, that is reasonable management action.
And almost by implication that if someone hasn't psychologically moved through their hurt, then kind of, there's nothing more we can really do about it within a legal kind of context. Whereas I would say that when I've watched or been supporting somebody through these processes, that an organisation might say that they are following procedural fairness process, that this is where quality of the conversation, to your point, kind of comes in, because in these meetings that are happening, if they're too mechanistic and too process orientated rather than interpersonal, which is what that paper, when we discussed about conflict, was really highlighting. It's about the intrapersonal. It's not about the process usually for a psychological harm. It's about the intrapersonal. And if in these processes, the reality of, Greg, you really hurt my feelings when you said that, and that Greg doesn't say that, okay, I hear you, and yet I really shouldn't have said it that way, and I really apologize for hurting your feelings in the way that I said that. If that kind of doesn't happen, then a person is much more likely to stay intrapersonally stuck in regards to the conflict, irrespective of what kind of bouncing ball, to use your famous bouncing ball kind of phrase, has been put around the discourse. That's what I observe. That's what I think happens. Yeah.
But I think in some ways, again, probably more than any other, certainly the issue I touched on before, this gap between the management of the risk and legal risk management. In some ways, we've set ourselves up to a position where we the way we manage the legal risk almost precludes us from doing some of the things that you are talking about to manage the psychosocial risk. Well, we can't, because we click over into some sort of investigative process in our organisation through our grievance procedures, it kind of precludes somebody, particularly if there's a disciplinary action attached to it, that kind of precludes me from coming and saying, no, I'm really sorry, I didn't mean that, because hang on, I'm being investigated now.
Yeah.
Not only do I have to stand my ground, I have to double down, and these are all the reasons why I did what I did.
Yeah. And everyone backs off into their respective corners and off it goes.
And I think that it becomes even more cynical because of the number of cases that and you talk to any lawyer who operates in this area, we see the number of allegations around psychosocial things, bullying, harassment, whatever, that are linked to or follow performance management processes makes a lot of people really cynical about this stuff, about the genuineness of it. And, and that's when, and because they're expensive claims, we run into the sorts of dilemmas that New South Wales and Victoria are trying to grapple with at the moment about how do we create, what are the guide rails that we want to put around this stuff? What does it look like?
And I think you're right in terms of, the back and forth in terms of our different perspectives is so rich in this conversation, because I listen to you say that, and, because it's after performance management, it results in people feeling skeptical, right? Whereas in my brain, I go, if it happens after performance management, it makes all the more sense. There is nothing more potentially unsettling psychologically for a human being in a workplace environment being told that they're not good enough. Of course, at a human level, when you're being told that you're not good enough, and then you add to that because you're not good enough, your financial security is at risk, which is always an underlying kind of theme to performance management processes, because it could be that your job is on the line. Psychologically, it makes perfect sense that people, A, are going to feel really distressed, right? And B, if that's not heard and felt and experienced during that process at a really human level, then of course the person is going to have a response to that. Am I making sense? Is that it's just, it just makes perfect sense to me why it happens in performance management situations.
And this is why the management of psychosocial risk, I think, is such, I don't think it's innate in many people. It has to be such a learned skill. And because, you always draw on your own experience. And I think of my own experience of, my whole working career, not just in the law, but everywhere else, has been shaped by performance management to a greater or lesser degree, and it's born in the late 60s. You sort of grow up as you do. Most of the performance management review was not about what a good job you were doing. It was inevitably the critical feedback. And so I think there is socially, there is a significant disconnect between people who believe, rightly or wrongly, and of course we all look back and say, oh, we were tougher and we were harder and we did, or not all of us, but what I mean. This is the sort of criticism I got on the way through. Why can't you put up with it and respond as I want you to respond? It's difficult and problematic. Anyway.
Which is really important. Yeah, I think that's really important, though, just to anchor in some workplace mental health strategic kind of structure in terms of the 3 pillars of an integrated approach. And therefore why, when you look at something like a performance management process or talent management processes in organizations, that it is really important in the way that people are trained, and performers and whatever that are around, just to guide leaders about how to do that stuff, that what you are doing well needs to be part of the conversations. Because if all humans ever hear from somebody is what they need to do to improve, to your point in terms of that was the way it was done when I was a boy, we know psychologically that means that people aren't going to be as receptive to the moments when they need to be told something that they need to do differently. So I do think that all kind of forms part of the holistic approach to controls and risk management in this space. it's very relevant. Hey, I wanted to ask you.
But that's sorry.
Yeah, you go.
Can I just quickly on that? That's why it has to be systematized to a degree within the organisation, because it's not innate in a lot of people. I think. Sorry, you want to ask me? Go.
Now there is a point in this decision where they refer to an investigation being conducted, a previous investigation being conducted under privilege. Now, I'm really keen to understand what you can share about moments when investigations into performance or into moments where investigations, it's fair and reasonable, or why would it be okay to conduct some investigations under privilege and some investigations not under privilege? Tell us about that.
Well, there's a whole episode in that, so I'll be quick.
Okay. If there is, then maybe. But if there is a little tidbit that people can understand, because to me that was very interesting to see that.
Yep. So just briefly by way of background, ordinarily if you conduct an investigation in your organisation, your normal investigation, that's what we would generally refer to as a discoverable document, which means that in legal proceedings, any third parties can get hold of it. It might have to be given to a regulator. So I do a review and say, there's all these allegations of behaviour. We've done an investigation. We've made all these adverse findings. That has to be handed over. If it's done under legal professional privilege, the short version is it's done for the purposes of getting legal advice, and it doesn't have to be handed over. Okay? And investigations are problematic. I'm doing some work with a new training program on this at the moment. But there are numerous, for example, unfair dismissal cases where a worker has been terminated for doing something unsafe, and then the safety investigation finds all these systemic problems in the organisation about all the things and processes that we didn't follow as an organisation. And that gets brought up in the unfair dismissal, where the commission says, well, it was unfair to terminate this employee for their conduct when you as an organisation had so many problems over here. That's how they can be problematic. In this case, the commission largely didn't have any regard to the investigation. And I noticed there's a comment in there where the commission specifically didn't form the view about whether the investigation was still privileged. You can lose privilege in a document. It has to be confidential and done solely for the purposes of legal advice. So if you do an investigation into workplace behaviour and you use that investigation to make findings and execute those findings, then it probably loses privilege because you're using it for two purposes, one to conduct disciplinary action and one for legal advice. And the commission in here referred to the company relying on parts of the investigation. I think, again, if you rely on parts of the investigation, you probably lose privilege.
Right. I raised that because I also think in the broader context of the psychological reaction, that the more that there's transparency, that you're going to have a better chance of maintaining trust with someone, and therefore the use of privilege, and therefore having, procedural mechanisms in place so you don't need to share something that person might.
Yeah.
I think it adds to the psychological distress often when that kind of stuff's happening.
Yeah, and it's always been problematic in a pure safety perspective. Like if you do a safety investigation under privilege, you're making a choice between learning from the incident and managing legal risk. Because if I do it under privilege, I can't share that information. I can't use it to develop corrective actions. I can't use it to inform my workforce. I'm using it to get legal advice.
Yeah, gotcha. It's a really good distinction.
Again, don't want to dive in it too far, but you can waive privilege. So what I often do, and lots of lawyers would say, do a privileged investigation initially, understand if there's any legal risk, then you can make a decision about whether or not you're going to waive privilege and use that information, or do another investigation, or whatever you're going to do.
Right, gotcha.
But we can do a full episode on privilege in that context. But yes, you hear that from workforces all the time about how privileged investigations undermine their trust and confidence in the organisation.
Yeah.
It happens. So I want to swing around and just talk to the main issue of reasonable management action in this case the case is good because it sets out all those criteria that we talked about reasonable management action, and, it's got to be objective and it can be a reasonable course of action even if some of it isn't. The fundamental reasonable two things. I want to talk about reasonable management action, and I want to talk about some of the observations of the court that show the deficiency of the legal process in a psychosocial risk perspective. So the reasonable management action one was dealt with quite shortly. Again, paragraph 79, if you're interested. The commission accepts that it was not unreasonable that the applicant thought that the complaints being made against her were part of a campaign against her, and it's not unreasonable that she was distressed about those complaints. But one of the elements of her complaint was that the company shouldn't have accepted nor investigated the complaints fundamentally. And the commission quite rightly dismissed that. They said, look, the receipt of the complaints by management and the conduct of the investigations wasn't unreasonable, and indeed the course of action was the only reasonable and prudent response. And I think that has to be right. I think if a matter is bullying or harassment or something like that is brought to the company's attention, I don't think they have any choice but to investigate it, even more so with the provision of psychosocial regulations in the work health and safety legislation. I think you're duty bound to investigate those complaints and to understand whether your systems to manage those risks are effective.
There is also reference in the decision to an anonymous complaint that wasn't investigated, and that the decision in that the judge or the commissioner in this instance said that was reasonable. Why do you think that was seen as reasonable, yet the other complaint that you're talking about was seen as not worthy or fair enough to not investigate that other complaint?
I think this is going to become more interesting over time. Bearing in mind this is an older decision, it's a 2014 decision, so this is 10 years ago. I think as a general principle, always been accepted that, anonymous complaints, unless you've set up a mechanism for anonymous complaints, right? So you've got a whistleblower system, for example, which is specifically designed to keep people anonymous. They probably do require investigation. But normally if somebody makes anonymous complaints, unless there is something in the complaint that would give you something to investigate, very often it's just practically not possible to investigate. If you don't know who's made the allegation or what the circumstances relate to or anything like that, and there's nothing to investigate.
Yeah. How can you look into it?
What I would say about that, though, again, the recent influence of work health and safety legislation in this space may be putting more of an onus on employers to investigate anonymous complaints if there is something in them that they could follow. So if there's complaints of unacceptable sexual misconduct in a workshop, someone puts that in anonymously, I'm not sure that you could just ignore that without making some sort of inquiry and seeing what that looks like. It would be difficult to do. It would depend on what's in the anonymous complaint, but I think there's an increasing emphasis on that.
But then that takes us back to the thing around what if people don't want to give evidence?
Well, again...
So you go to investigate something and then people say, so...
Yep. I think you're running straight into a reasonableness argument. Your Honour, we made these inquiries, nobody wanted to say anything, there was nothing more we could do. I think that's where you end up. It's that tricky judgment call between doing nothing and doing something that might go nowhere, but you could potentially inflame a situation. Yeah, there's risks either way. We often talk about investigating psychosocial matters in particular. There is no risk-free way to do it, either legal or potential for increased psychosocial harm, in my view. You're always trading off in doing that. The other thing from the case that I thought was worth noting was the recognition in the decision that while A, bullying did not occur, and B, the conduct by management was reasonable management action, the Commission was pretty overt in saying this could have been done better. So in paragraph 87, when they're talking about there was the allegation by NP, that one of the earlier ones, the Commission said that the HR and the company, HR being HR, the department, not the person,
Yeah.
should have been more proactive in ensuring that support was provided. And in paragraph 89, it talks about a team meeting and some issues there, and it says it's unfortunate, though not intended, that this represented a lost opportunity to more fully support the applicant given the tensions in the workplace. So there's clearly a recognition, and that's not uncommon at all in these sorts of cases where the commission comes out and say, yes, this could have been done better. Yes, there were things that, there were opportunities to intervene that might have prevented this, all of that sort of conversation. But at the end of the day, the conduct was not bullying because it was not sustained and unreasonable and creating a risk to health and safety. And the conduct complained of was reasonable management action. It's a very common outcome in these sorts of decisions.
And a helpful one, I think, and one that, in my understanding of the content and focus that goes on a lot in some of the manager training that's happening around the sector or around the corporate world at the moment, is that, and I know that this gets your goat, that kind of fear angle, using the legal fear angle to try to get leaders and organisations to engage in a product or a training or something or another. Whereas, and you can see that particularly in this bullying area, like, we've got to do training on bullying because, leaders are the people who need to do this well, But to me, again, thinking through what are the protective factors as well as what is the reality of something that would be really helpful for leaders to understand is not just what is bullying, but also what isn't bullying, and to have as part of that training almost like a sense of comfort that if you're not, that these cases that we're going to back you, that the organisation says, look, we know that if you do something a little bit not perfectly, or even if you do something quite a lot not perfectly, is what some of these cases are showing, is that doesn't mean that you're going to get found to have been a bully, right? And I think that overarching principle of an organisation saying to their leaders, you don't need to be perfect, but don't repeatedly and deliberately go around being really, really harmful, right?
Yeah.
I don't know.
I think you're right at a theoretical level. You're right. I think the problem for organisations is the only way you definitively find out is to be taken to court. And that's a process. I'll tell you one thing that's interesting. We might discuss this more next week, but it'll be interesting to see if the proposals in New South Wales and Victoria do end up going through. And I think the outcome, because this is what the designed outcome is you get less the claims for psychosocial harm being accepted in the workers' compensation system, whether that would result in an increased number of complaints or corresponding or similar increasing number of complaints to WorkSafe, because WorkSafe clearly isn't bound by those kind of considerations. So there's the psychosocial harm. I don't want to call it an experiment because that sounds a bit dismissive. It's not meant to be, but the sudden extraction of it much more into mainstream legal and management processes, I think it's still got a long way to run before we settle down on some sort of equilibrium on what this looks like for people.
Well, any kind of key takeouts that you see for employers or people listening from that case discussion, Greg?
Yeah, I think
as we summarise and bring our conversation today to a close.
To me, well, look, given the focus on this was reasonable management action, I think one of the key takeaways is honest and genuine compliance with your own internal processes, is setting aside that it might not always be good for the psychosocial health and well-being of your people, which is disappointing, will often be your best evidence of whether you're taking reasonable management action. So I think that is something that organisations need to grapple with.
And I think for me, it is anchoring back in the irrespective of whether reasonable management action is your as an employer, you're thinking that you've followed your processes, therefore it's reasonable management action, and that's the what. If you want to also bring in the let's actually try to minimise harm, not just follow the process so that we can say that we've followed our process, then it will be about the quality of those interactions. It will be about the quality of the conversations. It will be looking for not just to follow your process, but to actually look out for and listen for, if someone has had their feelings hurt, a mechanism of genuinely acknowledging that and doing what you can to say sorry for that.
Yeah.
Which is at the core of human to humanness, really, is that we take care and feel bad and say sorry if we hurt someone's feelings. So with that, we will, do you want us to give it, we get the what and the how. Do you want to give us a taster for what you're planning for our final episode in Reasonable Management Action with your colleague who's the workers' compensation expert?
Erica, yeah, she's agreed to come on next week and have a chat. And it's really just looking at the notion of reasonable management action in the context of workers' compensation. What's it looked like in the past and what might the future hold for us, I guess.
Great. Well, thank you, Greg. Another wonderfully interesting conversation. Thank you so much for spending some time in the bar with me today and with everybody else. And have a good weekend.
Pleasure, Kate. You too.
And thank you. And thanks for listening, everyone. And we will be back again in a fortnight. Cheers.
Thanks all. See you next time.
That's a wrap for another episode of Judgemental. Thanks again to our sponsors, EML. EML's Mutual Benefits Program provides organisations with free services, tools and resources to manage their workplace risk. You can follow EML, myself and Greg on LinkedIn, and be sure to check the show notes for links to the papers referenced in each episode, as well as resources available to help you as you navigate the wonderfully complex and nuanced world of psychosocial risk. See you again next time at the bar.